services provided by the triage individual, by the screening process, including, and we felt strongly that there should be screening for any process, including court. Right now, there isn't any requirement for screening when you go into court. We thought that should be there. Obviously, the specialists in the field would have to be trained. One of the thoughts was that perhaps they could have a liaison with the specially trained police forces who deal with domestic violence. We all agreed that the screening person must see both people, ideally individually. We talked about the practice in Toronto, for arbitration purposes. Some arbitrators will allow individual screening. We thought that should not be permitted. In terms of how it would be funded, we thought about, well, okay, this is a user pay-as-you-go philosophy, but does the victim have to pay? So we wondered about that. Fast track, if it is a domestic violence case, obviously you want to fast track to a safe process. Now we normally think of that as court, but we also realize that court isn't always the safest process. Maybe mediation or collaborative law even might be a process that, with the proper protections in place, might work. How do we liaise the screening process that's done privately with, if the mediation or whatever breaks down and the people end up at court? How do we liaise that with the court office? Obviously, we thought that there might have to be a form at the court office that you had to fill out to say whether or not you're in mediation, who you were with, and then that would lead to a request by the court for a filing. Because right now the court, for example, if you apply for custody and you're a non-parent, you have to supply the court with an authorization to get your CAS any CAS records that are out there, or you have to get a police check. So there could be another requirement that you have to give authorization for the screener to provide the court with information about the screening process. And what would that report look like? Well, we kind of have a template out there already that is used in the family arbitration process, where the screening party will sometimes be separate from the arbitrator, and that they will give a report to the arbitrator about the results of the screening, and that may lead the court or the arbitrator to take special precautions if there is domestic violence. So we've got that in place already that we can build on. In terms of the triage, we talked a lot about the business model of triage, and even thought that it might become a private enterprise. So-and-so company offers triage services. Obviously the training would have to be developed per a model. People would have to be trained, maybe even educational institutions could provide the training. You would get some qualification, some reliable certificate that says you're a qualified individual to do this. And we went through that quite a bit. We thought that if you're going to do triage for the majority of people, you could probably do it by telephone or Skype or some way electronically. We might be able to use local community leaders, people that are identified, that want to do the training, could do the triage within the community. We talked about traveling triage. You're on the road. There's thousands of cases that go into court every year in Ontario, and the volume, if this were a mandatory program, the volume would be very high, and so consequently the demand would be very high for this service. So how do you meet that? That's going to be one of the hard issues. How do you fund it? Well, at our table we talked about using perhaps employment benefits packages. I think employers probably agree that marriage breakdown has a huge impact on the productivity of their workers and therefore their bottom line. And would they begin to fund these services through EAP programs or benefit packages, something of that nature? Would we have the users pay for it? But then there's a problem with that, because if it becomes mandatory, if triage becomes mandatory before any of these processes, if people have to pay for it, and it's mandatory in the court system, you can rest assured that the court system will not require people to pay for the service, because that is an access to justice issue. So if the court system develops a triage process where they're going to compel triage as part of that process, then people are probably going to still opt for court because they don't have to pay for the triage process. So that's going to be a tension we have to address. The court system is going to compete with the business model without any doubt. And overriding all these things, of course, is the quality control and evaluation process. You got to make sure that the professionals who are providing the service are properly trained, qualified, and that they're doing the job that we want them to do. So that's why we didn't get to the actual dispute.
Thank you very much, Tom.